Namaste and welcome to our YouTube series called TIL Legal Fundamentals. This is Harini Daliparthi, Senior Associate at the Indian Lawyer and Allied Services. The firm introduces the seventh episode of the series, that is Law of Injunctions. For more videos on contract law and beyond, do visit and subscribe to our YouTube channel called The Indian Lawyer and Allied Services. Thank you.
Meaning of injunction. Injunction is a preventive relief granted at the discretion of a court to compel a party to do or not to do certain acts. Parties have to abide by the court order to prevent future injury. Injunction is also an equitable remedy which is usually granted when a breach of contract cannot be effectively remedied by an award of damages. As granting of injunction is an equitable relief, such a power can be exercised by the court when it is absolutely necessary to protect rights and interests of the applicant. Conditions for grant of injunction. An injunction can be applied at any stage in a court proceeding, but the court would examine the following pre-essential conditions before granting or refusing injunction. First, that there is a prima facie case, that is, a serious disputed question which has to be adjudicated by the court. Second, the court's interference is essential to protect the party seeking relief from irreparable or apprehended injury. Third, the balance of convenience is in favor of the party seeking such relief. This means that the aggrieved party has a prima facie case on merits. Next, the aggrieved party has approached the court with clean hands, that is, without any dishonest intention or unreasonable delay, etc. In a Supreme Court judgment of Executive Committee of Vaishya Degree College versus Lakshmi Narayan of 1976, the three-judge bench held that the appellant university was liable for breach of contract of services of the respondent and allowed damages for such breach. Further, the court, however, refused to grant injunction restraining the appellant from interfering with the contractual services of the respondent on the following ground. The apex court observed that if injunction would have been granted, it would have resulted in reinstatement of the respondent, and the appellant would have had to pay the respondent a backdated salary for 9 long years. This would have caused a financial loss to the appellant university, adversely impacting the interests of the students. Thus, the Supreme Court directed the appellant to only pay damages to the respondent. Conditions for refusal of injunction. The court may refuse to grant injunction in the following circumstances. First, if a person having a right to object consents to the violation of his right, then he is not entitled to the discretionary remedy of a mandatory injunction. Next, if the effect of grant of injunction is nullified by certain developments that have taken place during the pendency of the suit, or if the person has not shown any due diligence in applying to the court for relief, then the court may refuse to grant injunction. Also, in case of triviality of damage to the plaintiff, mandatory injunction may be refused. In case of existence of an imbalance between the injury and the right to injunction, the court may refuse injunction. Types of injunctions. In India, courts have generally granted the following types of injunctions under the relevant provisions of Specific Relief Act 1877 and the Code of Civil Procedure 1908. First type is temporary injunction. A temporary injunction is an interim relief granted by a court during the pendency of a case in order to protect the rights of a party and also to prevent future injury until the case is finally heard and disposed of. It is an interim relief granted in aid of and as ancillary to the main relief available to the party on final determination of the rights of the parties. A temporary injunction is generally granted for the following reasons. 1. To preserve the status quo in respect of the subject matter of suit. 2. To restrain the defaulting party from alienating, damaging, or otherwise from causing injury to an aggrieved party. Third, to restrain the defaulting party from committing a breach of contract. Provided that the defaulting party has been issued a prior notice about the proposed injunction proceedings. Further, if the defaulting party breaches or disobeys the said order of injunction, then the court may order for attachment of the property. It may also detain the defaulting party in civil prison for a term of up to 3 months. In a Supreme Court judgment of Adhunik Steels Limited versus Orissa Manganese and Minerals of 2007, the two-judge bench granted interim injunction in favor of the appellant under the provisions of Specific Relief Act and CPC and directed the respondent from interfering with the appellant's work in terms of their contract and restrained the respondent from entering into a contract with third party. Next, perpetual injunction. A perpetual injunction is granted by a court to perpetually refrain or forbid the defaulting party from committing an act which would be contrary to the rights of the plaintiff or aggrieved party. A perpetual injunction is a final relief and continues forever. It can only be granted by a final decree which concludes the rights of the parties forever. As a result, the plaintiff will be restored to the position in which he stood prior to the commission of the acts complained of. It is generally granted when the defaulting party invades or threatens to invade the property of an aggrieved party and when such invasion cannot be adequately remedied by way of damages. But in certain cases, the court may refuse to grant an injunction to prevent breach of a contract where the performance of such contract cannot be specifically enforced. In such cases, the court may allow only damages. In another Supreme Court judgment of Dalpat Kumar and another versus Prahlad Singh of 1992, the two-judge bench refused to grant injunction to the respondent as damages was sufficient to remedy the act of dispossession by the appellant. Prohibitory injunction. A prohibitory injunction is granted by a court to prohibit or restrain a person from doing an act or omission. In a Supreme Court judgment of Niranjan Shankar vs. Century Spinning of 1967, the two-judge bench held the appellant liable for breach of contract and further granted injunction to restrain the appellant from divulging confidential information about the respondent company to its competitors. The said injunction was granted to protect the interests of the respondent company. Next, mandatory injunction. A mandatory injunction is an order requiring the defendant to do some positive act for the purpose of putting an end to a wrongful state of things caused by him and fulfill his legal obligations. A mandatory injunction is also granted to prevent the breach of a contract where performance of such contract can be specifically enforced. It is granted to undo something or to do a particular act to restore things to their former condition. The limitation period for filing a suit for enforcement of a decree granting a mandatory injunction is 3 years from the date of the decree or from the date fixed for performance of such decree. In another Supreme Court judgment of Dorab Warden vs. Kumi Warden of 1990, the two-judge bench upheld the order of interim mandatory injunction issued by the trial court, which had directed the respondent to vacate the premises and had refrained the owners from parting with possession of the suit property until the suit is disposed of. So that is all we have today on law of injunctions. We thank you for watching our video. For any further queries, you may please contact us on any of the options given towards the end of this video.